welcome to Case in Point, produced by the University of Pennsylvania Law School. I'm Steve Barnes. In this episode, Ted Ruger, Dean of Penn Law, speaks with Nina Totenberg, legal affairs correspondent for National Public Radio, about her insights and experiences covering the United States Supreme Court and what the future may hold for the institution.
Nina, thank you for being with us at Penn Law today.
It's my pleasure.
You've covered the court through many election cycles. How, if at all, does a presidential election impact the court or the coverage of the court?
Well, it definitely has the potential to influence the court, especially this year, because there's a vacancy on the court. And it's, as you can see in a number of important cases, the court has been tied, which means that the lower court opinion stands. In most cases, though not all, that means at the moment that a somewhat more liberal result stands, because the Obama appointees now are a majority on most but hardly all of the courts, lower courts. So the next president, if you're talking in actuarial terms, has an opportunity in all likelihood to not only pick somebody to fill this vacancy, but to fill as many as, I would say, three more. Justice Breyer is 78, Justice Kennedy is 80, and Justice Ginsburg is 83. And if we were writing an insurance policy, we would say the likelihood is that one or more of those people is going to leave voluntarily or involuntarily. So that's the status quo, and it will have a profound impact on what kind of court we have. We've had a basically conservative court for a long time, with some notable exceptions like same-sex marriage. And should Hillary Clinton win, it would be the first time in a half century that we would have a majority of justices appointed by a Democrat.
So to follow on that, judges serve, Supreme Court justices serve for a very long time in some cases. To what extent have you seen in your career covering the court justices who evolved or surprised perhaps the president who appointed them? How fixed is this choice that the next president will have?
Well, I would have to say that I have seen many justices turn out to be either less liberal or less conservative than their appointers thought. But in the most modern times, I would say that Republican appointees are pretty fixed because they are very, very conservative. They have a track record. They are not picked because they're going to change their minds. And they haven't. By and large, they haven't. Democratic appointees are pretty liberal. I would say somewhat more moderately liberal than the Republican nominees are, or appointees are, conservative, but perhaps because there is a yin, there's also a yang. Mm-hmm. And that means that the court is not like it was when I first started covering it, when there were liberals and conservatives, and they did not at all, they were shuffleable on many issues, and that's less and less true today. Mm-hmm.
To follow on that, and as you're a keen observer of the different liberal and conservative dynamics on the court, is there an opinion in the last year or two that's surprised you on the day it came down in terms of the way the justices voted?
I would say the most recent surprise was probably Justice Kennedy's opinion on affirmative action in higher education.
That was Fisher versus Texas.
Yes, and that case had already been there once, was sent back to the lower court. They then granted the case for review, suggesting they didn't like what the lower court had done, which was to uphold the University of Texas affirmative action plan. And Justice Kennedy has, for a very long time, been extremely suspicious, even hostile, about affirmative action plans, even in higher education, while at the same time saying that he understood that there might be a need for some sort of plan. He had never seen one that passed muster with him. Mm-hmm. And for the first time, he not only endorsed this plan, but wrote a pretty broad opinion about the need for diversity in higher education and how using race or ethnicity as one of many factors was a legitimate, even important thing to do. And so I would say that definitely surprised me.
As we sit here in a law school, we think a lot about teaching advocacy, and of course we talk about written advocacy, and with the Supreme Court, one thinks of oral advocacy, and you've sat in on hundreds, maybe thousands of oral arguments over the years. What do you think are the attributes of persuasive oral advocacy that you've seen matter at the Supreme Court?
Well, I think the maxim is probably true in general, which is that it's hard to win a case at oral argument, but you can lose one. And I think that's generally true, although there are cases where I've seen people win. And it's usually when they've added something, an argument, a point of view that's not entirely reflected in the briefs. It's not that it hasn't been briefed, it's that it's a different window, a different way of looking at it. And where the advocate has figured out also an answer to the critical question, which is, if not this, then what? If you're talking about a federal regulation, okay, where do you draw the line? You have to be able to tell people on the court how to draw a line. And if you can't, they'll draw it on their own. If you want it drawn in a particular way, you have to give them a reason to draw it there and a pragmatic reason about how it will work out.
Has the feeling of oral argument and the atmosphere and the dynamics of the oral argument changed in the Rehnquist and Roberts court compared with the earlier courts you covered?
Oh yeah, I mean it's like night and day. When I started covering the court, they were pretty quiet affairs, with the occasional interjection of a question, and every once in a while it would heat up. But now it's not unusual for there to be 75 questions during a half-hour argument, and an advocate is lucky if he or she gets a whole answer out. And that's one of the real skills these days, is to be able to actually answer, give an answer, get most of your answer out when you're getting pummeled from the right and the left. And it's a bit of a trick, and not even the most skilled people can do it all the time.
Give us the name of can you give us kind of the best oral advocate you've seen in the last decade, or somebody who impressed you?
There are these days, when I started covering the court, every Tom, Dick, and Harry who had a case before the Supreme Court, and there were twice as many in those days, mainly handled their own. And that meant that some of them were to say they were ungood would be charitable. They were rotten. They were terrible, they were embarrassing, they gave answers that infuriated the justices, even occasionally were racist. So now there is much more of a professional Supreme Court bar. The same people argue more and more often, and there might be, let's say, 20 of them that are repeat people in a term. And they're very, very good people. And so I'm not about to pick one of many. I mean, you could say that, Paul Clement is a brilliant advocate, but so are many others. Anybody from, Carter Phillips or Seth Waxman or Tom Goldstein. I could just, there are just tons of them. And there are young ones coming up too, who are very good and are beginning to build a practice of their own. So, in some ways, Don Verrilli got a tough rap when he argued the ACA case, the health reform case, but in fact he won the case. And he has been a perfect advocate for the Obama administration in this period of time, meaning he's not a bomb thrower. He really wants to have a conversation with the court. And after, I'd say, the first year of his tenure, and he was there 5 years, he figured out that he couldn't do what he'd always done when he was a commercial advocate or occasionally even a pro bono advocate at the court, that he needed to shove back harder. And he learned to shove back harder, but in this nicest of ways. And I think it really worked. It was a combination of civility and a little bit of, don't shove me around that way. I've got an answer for you. And I thought he was really brilliant at it. And I don't know whether he'll go back to practicing law before the court or not. He's taken a little hiatus, but it was really interesting to watch his evolution.
So here's a question much more explicitly about the media and the coverage of the Supreme Court. How has that changed over the past 4 decades in terms of the number of media outlets that have specialized Supreme Court reporters, and what do you see as the future of kind of Supreme Court media coverage?
I actually don't think there are more media outlets that cover the Supreme Court per se. First of all, there are fewer newspapers, just period. When I started covering the court, there were big newspaper chains that had people who regularly covered the court. They covered other things as well, but those folks aren't around anymore. So there are a handful of big newspapers and the wire services. Again, there are fewer of them. And the networks have people who come in episodically when they need to, and NPR. And then there's the blogosphere. And SCOTUS blog is, I could say, the leading Supreme Court blog, but it's really the only one that's taken seriously anyway. There are other blogs that occasionally blog about the Supreme Court or about specialized parts of it, that's mainly the what would I call it? The professoriate. Professors write blogs. Some of them are very good. Some of them I really rely on. Others I don't have time for. So I wouldn't say it's a bigger press corps at all. It's relatively small. It's probably, of the regulars that have a so-called hard pass, meaning you can walk through the metal detector at the front door and they don't make you check everything. Maybe 20 of us or 24 of us, something like that. It's not a big press corps, but it is a very hardworking and skilled press corps for the most part. I mean, these are people who read briefs day in and day out, conduct interviews with lots of the professoriate and other people, and it's probably a more thorough press corps now than it ever was before. You can't get away with just covering the big cases because there's too much else going on, and people want you to cover almost every jot and tittle, not everyone, but so it's somewhat different covering it now. I mean, I cover it for the radio. I do stuff for our digital page. I tweet. There's just a lot of stuff to do. I used to cover, when I first came to NPR, I covered the Supreme Court, the Justice Department, all the special prosecutors, the House and Senate Judiciary Committees, not just occasionally, but a lot. Any big scandal of any kind, because it had legal implications. I covered impeachment, God knows. And also the intelligence community. Now, we probably have 10 reporters who cover all that stuff now.
Thank you. Well, thank you for being with us.
It's my pleasure.
We appreciate your insight.
Thank you. Thank you for having me.
And thank you for joining us on Case in Point.